हाय फ्रेंड्स, सब्सक्राइब दिस चैनल एंड लाइक दिस वीडियो। दोस्तों, ये डिक्टेशन 100 वर्ड प्रति मिनट की होगी, जो लीगल वर्ड की मैगजीन से लिया गया है। 10 सेकेंड्स, 5 सेकेंड्स, स्टार्ट। इट मे बी so embedded in the act itself as to become an integral part of the enactment and thus acquire the tenure and color of the substantive enactment itself, and it may be used merely to act as an optional added to the enactment with the sole objection of explaining the real intendment of the statutory provision from the aforesaid legal position, having regard to the context of the statute to which the proviso in question is appended. We are of the considered opinion that the proviso used in section 33 of the Act number 1 of 1996 is just like exceptional to the main enactment, for the simple reason that the duty which is caused upon the appropriate government by the main substantive part of section 32 and section 33 of the Act to identify the post in the establishment which can be reserved for the persons with disability. The proviso has relaxed the rigor of statute, and having regard to the types of work carried on any department or establishment, the appropriate government is given liberty to exempt any establishment from the operation of the main provisions of section 33 of the Act, subject to conditions, if any, as may be specified in such notification. Thus, in our opinion, the role which is played by the proviso is to carve out an exceptional to the substantive part of the statute contained under section 33 of the Act. Now we will examine Act number 1 of 1996 from its constitutional point of view. From a mere survey of various provisions of the Act, it appears that the Act in question is very comprehensive legislation, and it has been enacted by the Parliament of the implementing the decisions taken in the aforesaid international conference, which is referable to the provisions of Art 253 and entry number 13 of list. The 7th schedule of the Constitution already references the aforesaid provisions and enacted are under legislation to giving effect the international agreement, notwithstanding anything in the forgetting provisions of this chapter. Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries, or any decision made at any international conference, association or other body, participation or international conference, association and other bodies, and implementing of decision made thereat. The bare reading of the provision of under Article 253 of the Constitution indicated that the Parliament has power to make any law of whole or any part of the territory of India for implementing by treaty, agreement and convention with other country or countries, or any decision made at any international conference, associate or other body, notwithstanding anything of foregoing provision of this chapter। दोस्तों ये 100 वर्ड पर मिनट की डिक्टेशन थी, इसको आप ट्रांसक्राइब कीजिए और